You aren't lying effectively.
Okay. My name is Thomas Prol, adjunct faculty at New York Law School, and I'm an attorney with the law firm Cardinale Hollenbeck. I'm also a trustee of the New Jersey State Bar Association. I thank you for your time tonight. I know it's late. I know we've all sat through 7 hours plus of testimony tonight, and the one thing I'll point out that is that not one person has come forward to tell you that this law is actually working. You've had a great deal of testimony of people telling you the pitfalls, the failures. You've had representatives of the State Bar come forward and talk about how their clients and their member attorneys are coming forward to talk about the problems with this law. And I want to point out 3 issues. The first, I want to note that a question was raised earlier about why would we consider changing the law when we have not done due diligence? And the first thing I would point out to you is that's what we call the Civil Unions Review Commission. The legislature set up the Civil Unions Review Commission to provide an answer, and they did. Hours and hours of testimony. Couples came forward. Many people came forward and testified about the failure of that law. And still, at that time, no one came forward to tell you the law was working. We also learned a great lesson from the state of Vermont, and we learned there that over 10 years, that tragic history of that law, after 10 years, that law never achieved equality in that state. And the reason why is a matter of perception. And I want to talk to you in particular about the ERISA law, because a lot of us are getting confused by the issue of this being federal law. The issue with ERISA is a matter of perception. What you have in Massachusetts is couples who are married, capital M, go to their employer, and even though their employer is under an ERISA-governed plan, that employer still provides benefits. Where you have in New Jersey, a couple that is married under or civil union under New Jersey law is not provided equality because they do not have a marriage. ERISA speaks to marriage, and putting aside the Defense of Marriage Act and putting aside any federal law implications, what happens in Massachusetts is the employer will see the word marriage and they will afford them benefits. In New Jersey, the employer will see the word civil union and not provide them benefits because the law speaks to marriage. Now what happens is in Massachusetts, if they choose to discriminate, and that's what it becomes, it's a choice to discriminate, they'll reach through the word marriage and they'll say, yes, we understand that you're married, but in fact, we're going to look at the definition of marriage under federal law. We're going to look at the definition of marriage under the Defense of Marriage Act. And so they reach through and they have to affirmatively discriminate. And that's the huge gap, one of many in the civil unions law under New Jersey law that makes this law unequal. The other thing I'll point out is I know the good Senator Cardinale pointed out his concern with the way this law is drafted with regards to how the marriage will, or the law is proposed to elevate civil unions automatically into marriages. And I would ask you, senators, look around this room, who do you think would have a problem with that, elevating their civil union into an equal marriage? What I'll tell you is for the last 3 years, this state has actually taken marriages from other jurisdictions and devalued and demarried them when they come to New Jersey. So when you have a marriage of a same-sex couple from Massachusetts, from Canada, from Belgium, from any of the other countries that provide equality in marriage, when those marriages come to New Jersey, for the first time in the history of this state, it upsets hundreds of years of jurisprudence under the common law principle of comity and under the full faith and credit clause, and we convert those marriages, we devalue them into civil unions. And that's an affront to our Constitution, that's an affront to the common law. And so I would leave you with that. That's the status. Civil unions can never be equal to marriage. Well, one last comment. The Catholic Conference of Bishops, I commend them for finally going on record and acknowledging that same-sex couples should have full equality. But they talk about fixing the loopholes, and that begs the question, if there's loopholes that need to be fixed, the best way to fix it would be to go to marriage equality. What I can tell you as an attorney who practices regularly in these areas, there is no way you're going to fix these loopholes. No amount of amending, no amount of changing, no amount of tweaking is ever going to fix the problem here, because it's the perception that's the problem. And you might work on drafting new words and trying to fix the problem, but Vermont is instructive on the issue of how this equality can never be reached with another separate statutory construct like civil unions. Only marriage equality will solve this problem. Thank you.
Thank you. Senator Cardinale.
You mentioned at the beginning of your testimony the commission. Can you, with a straight face, say that commission was organized and peopled by folks who were unbiased on this question?
The Civil Unions Review Commission?
Yes.
Well, I know that the legislative body set that up, and with all due respect, you were part of that.
That's not my question. Yes. I know how it was set up.
Right.
Can you tell me, you've looked at them?
Yes.
You've cited them?
Yes, I appeared before and I testified.
Can you, with a straight face?
Yes.
You're not sworn in.
I'm an attorney at law, so I think we can assume that I'm under oath.
Can you say that that was an unbiased commission, that the membership was unbiased?
Yes.
Well, you know, someone once said to me, 3 years of learning to lie effectively, but you aren't lying effectively. Because I don't
You're calling me a liar?
Now, I've got a couple of other problems with what you've had to say.
I believe members of that commission came forward with their own opinions.
You asked us if there would be any folks coming before us today who would object to having their civil unions elevated to marriage without taking any affirmative action. And I agree with you. Those who testified here today probably wouldn't object at all. But you know, there's a lot of people who aren't here, who have civil unions. And if one of them didn't want this elevation, we're doing that person a disservice. Terrible disservice.
I think the greater harm is the disservice done to gay and lesbian couples.
Without their consent. The consent of the governed is a very important principle in our democracy.
Senator, are you asking a question? Senator Gill?
I think we may disagree, not you and I.
Oh, okay, thanks.
But I think we may disagree, but we don't have to be disagreeable. And even though there may be positions that I don't fully support, I don't feel that any person has come here today to lie before this committee. And so I think on behalf of at least myself, and I think I can say for this side of the aisle, you are not a liar.
Thank you.
And we apologize as senators for that statement. Thank you.